Good morning, everyone. We're going to get started. Good morning again. Welcome to the Buffalo Niagara Partnership Manufacturing Council session focused on employer liability protection strategy in the COVID-19 workplace. My name is Seth Piccarillo, and I am a Senior Manager of Economic Development for the partnership. As the region is navigating a phased reopening of businesses at this exact moment, liability protection for employers is both critical and timely, and it will be for the foreseeable future. We are excited to have a large group of participants registered for the session, including several Japanese companies, thanks to the Consulate General of Japan of New York. So from far and near, thank you all so much for spending your morning with the partnership. As always, thank you to the Manufacturing Council sponsors who make our work possible. Bank on Buffalo, our title sponsor. Industry sponsors, Harris Beach PLLC and National Grid, and supporting sponsor, Remedy Intelligent Staffing. Thank you to today's presenting sponsor and presenters, Schoeneck and King. It's a full service law firm that operates in 4 states. And thank you very much to attorneys Mark Moldenhauer and Jim Rooney for sharing their expertise on best practices to protect the future of your company while navigating governmental regulations and safety protocols. A few timely updates before we hand it over to Bond. From the beginning of the COVID-19 pandemic, the partnership has been committed to helping regional businesses navigate this unprecedented time. We created the COVID-19 resources and impact page on our website homepage, thepartnership.org, which will provide you detailed information from everything from financial opportunities, best practice documents for HR or legal, and even source products to help you with a safe reopening. We went a step further and created the BNP business link, which allows you to submit direct questions to us. We answer with the most up-to-date information or connect you with an expert that can give you more specific guidance. Both of those new features can be found at the homepage of thepartnership.org. Next Thursday, we are going to again convene the Manufacturing Council, June 4th at 8 a.m. and hear from the Bonadillo Group about navigating COVID-19 related lending, tax laws, and most importantly, the future of PPP. As we're talking about phased reopening, it's critical that all companies visit forward.ny.gov. Each business, as they're essential and have been operating or are reopening, need to take 5 important steps. They must submit a business affirmation to New York State, which you can do through forward.ny.gov. You must complete a business safety plan. You must have that plan readily accessible at your place of business. You must post that public plan in case a customer wants to review it, and you need to communicate that plan with your employees. So again, if you have not done so already, please visit forward.ny.gov. Also today, the partnership is excited to circulate the Keep Buffalo Niagara Working Guide to Reopening Your Business. It's an online document that has sources of the latest information, guidelines to help you open and operate your business safely during COVID-19. Before I hand it over to Mark, we are going to have a Q&A at the end of the session. You will see at the bottom of your screen a Q&A button, which allows you to type in your question. You can also, if you see a question asked that is important to you, you can upvote it so it gets to the top of the list. At the end of the session, I will read those questions as much as time allows. And with that, I'm going to hand it over to Bond.
Thank you, Seth. My name's Mark Moldenhauer. I'm a partner in Schoeneck and King's Buffalo office. Both myself and Jim Rooney, who will be speaking later on, practice in the area of labor and employment law. So for the last 3 months or so, we've been helping clients trying to navigate all these various issues that relate to the workplace, challenges relating to keeping their employees engaged to the extent that they can. And now we've kind of gotten to this point. Frankly, I think we're all very happy to get to this point where employers are starting to reemerge, reopen, and then even for those businesses that have been running all along, they're starting to bring more people back. And things are starting to get closer to normal. I think we're still a long way from normal. There's a lot that we need in the industries need to go through before we get back to that place where we can call it normal. The new normal will probably be different from what we were used to 4 months ago or 5 months ago. But we're adjusting and we're trying to stay nimble as these new requirements come out from the state. Next slide, please. And you could advance to the next. So these are the topics that we're going to cover over the course of the next 40 minutes or so. I'm going to spend some time talking about the various reopening requirements as we get more information from the state about what businesses need to do as they reopen, and with an eye towards making sure that we're providing the safest possible workplace for our employees, because the last thing we want is some sort of situation where our workplace becomes infected and a large portion of our workforce is not available to work, and as a result, even as the economy is starting to turn around and businesses are starting to turn around a little bit, a particular company can't participate in that to the fullest extent they were otherwise able to because of, frankly, workforce concerns. And then after I'm done talking about these reopening requirements, I'm going to pass it off to Jim, who's going to spend some time talking about certain leave laws that relate to COVID-19. And these are important, of course, because a lot of businesses have not been operating for the last 3 months. And now that they will begin operating, they need to understand how to work, how to function under the legal framework that has kind of developed over the course of the last 3 months. And that includes some important state and federal legislation that's going to affect a lot of employers. And then finally, Jim will talk about some general liability issues at the end related to COVID-19. Next slide. So I'm not going to go over this long timeline, and this is only a partial timeline. But I thought it was important to kind of set the table, so to speak, by just looking back for a moment to see where we're coming from. It was in the beginning of March 7th, that Executive Order 202 was issued by Governor Cuomo, declaring a state of emergency in New York. Over the coming weeks after that, we saw a number of restrictions be put in place with respect to social gatherings, and then eventually with respect to business-related gatherings, to the point where in the middle of March 18th, Executive Order 202.6 was issued, which required non-essential businesses to reduce their on-site workforce by 50%. And I believe that we had somewhere like 36 or 48 hours to accomplish that. Now, before that 36 or 48 hours even expired, Executive Order 202.7 was out, which required a further reduction so that non-essential businesses were down to 75%. Had reduced their on-site worksite by 75%, and then finally to 100%. So non-essential businesses could not have employees on site, with some very minor exceptions I'm not going to get into, okay? And they have been, to a large extent, if they haven't been able to operate remotely, mothballed for this better part of the last 2 months, 2+ months. Next slide. So we're kind of at a turning point, and we have been for the last couple weeks or so. We've gotten to this point. Things are starting to look better. Okay, end of April, Governor Cuomo announced a phased reopening plan for non-essential businesses, 4 phases depending on the industry. And to enter a phase, a geographic region must satisfy certain state metrics. May 14th, Executive Order 202.31 was issued, and it eliminated the on-site workforce restrictions that were previously established for certain phase 1 industries, and 5 geographic regions were approved to enter phase 1. Western New York was approved to enter phase 1 effective May 19th. So here we are. Now, next slide. Let's talk a little bit about the phase 1 industries. Some of this I suspect is probably a review for many of you. Construction, agriculture, forestry, fishing and hunting, retail, which is limited to curbside or in-store pickup or drop-off, manufacturing, of course, and wholesale trade. Next slide. So in the coming weeks, we hope that Western New York will be able to enter the phase 2, phase 3, and phase 4, okay? And the number of industries that are part of those phases will also be able to start. And frankly, the framework that they're gonna follow is very similar to the framework that was established for these phase 1 industries with respect to the guidance that's issued. Individual guidance was issued for each industry, okay? So there's a specific guidance for construction. There's a specific guidance for manufacturing. There's a specific guidance for the curbside and in-store drop-off, pickup, retail, okay? There's many common elements. In fact, there's more common elements than there are different elements in each one of the guidelines. But we have somewhat of a roadmap as far as what the state is trying to do as it goes through this phase reopening process. Next slide. So I just thought it'd be worthwhile to put together a list of who was deemed essential and what other manufacturers are now able to get going since we're in phase 1, okay? I'm not gonna go through this list. My understanding, I haven't seen recent statistics, but most manufacturers were able to keep at least some presence going, so some functions going, because they were deemed essential. Perhaps not 100%, maybe not even 50%, maybe some products had to be shut down because they weren't essential, but they were able to keep some presence going, okay? Others, not so much. So this is really their opportunity to get back in the game, get back in business, start up and get going again. Next slide. So regardless of whether a business is essential or not, okay, whether they were previously deemed essential under the prior executive orders or, whether they're starting up right now after, almost 3 months of being shut down, okay, they're required to comply with certain, mandates that have been put out by New York State, okay? They have to comply with certain people, places, and processes guidelines that were published for each industry by the New York State Department of Health, okay? As Seth mentioned before, each business is going to have to affirm that it's read and understand its obligations under those guidelines. And then each business is going to have to develop a written COVID-19 health and safety plan. And as Seth mentioned, that plan has got to be posted. It's got to be communicated to employees. And it's going to basically be the path that you follow to help ensure that your employees remain working in a safe environment, okay? Again, even if a business was essential and it was operating without regard to these new phase 1 requirements, okay, it has to kind of fall in line and follow the new requirements that are out for any businesses in its industry, okay? Fortunately, in many cases, businesses were already doing a lot of what's required in the guidelines. So it's not going to be a massive overhaul to fall into line and start abiding by these new requirements that are put out by the New York State Department of Health. Okay, next slide, please. So I want to go through some of the more significant requirements. This is not intended to be an exhaustive list. Frankly, all businesses are required, okay, to review and understand the guidelines. This is just going to touch on some of the more, perhaps the more significant requirements. And it does focus on the requirements. I should also state that in the guidelines, there's a number of best practices that are listed, okay? Those are exactly what they are. They're best practices. They're not requirements issued by the state. However, I would suggest that every single business consider those best practices to see what it can do, which best practices it could adopt. Because again, the goal is to try to the maximum extent possible, maintain a safe work environment for our employees. And so much else will flow from that, okay? As far as the guidelines, as I said before, they're really broken down into three categories: people, places, and processes. Under the people category are physical distancing requirements. One of the requirements is that every workforce is required to limit its on-site presence to 50% maximum occupancy. Okay. There are some wrinkles to that I'll go over, but you know, the 50% maximum occupancy is an important number. Now, so in some cases, there may be the maximum occupancy posted for an entire facility. In some instances, there might be a maximum occupancy that's been established for different parts of a facility. In either case, wherever the employees are doing work, the workforce present should be limited to 50% maximum occupancy. Okay. As far as the wrinkles that I mentioned, this does not include supervisors. The term supervisors is not defined in the guidelines, so businesses are going to have to make a reasonable determination about who it's going to exclude from that number to be taken into account for the maximum occupancy. Okay. Also, there's a big exception if more employees are required to safely operate core functions. Okay. The example that is in the guidance is if there is a line, an assembly line that requires a certain number of people in order to operate safely and effectively. Okay. If that is the case, an employer can exceed the 50% maximum occupancy. But I would suggest, I caution, that you want to be very deliberate if you're going to try to take advantage of this exception. Okay. Make sure that you can, if questioned, if audited, show that exceeding that 50% occupancy number is necessary to safely operate the core functions. Okay. I'd rather a business go through that analysis right now and make sure that they're going to be able to provide a good explanation, okay, than wait for an audit to happen. And at that point, you know, be scrambling to make sure that they can sufficiently document that. You know, be deliberate, you know, put some time into analyzing that issue right now. Okay. And if you are going to exceed the maximum occupancy, it's very important that the employer take additional mitigation strategies. Okay. What does that mean? Well, in some instances, it can include installing physical barriers between workstations, okay, to keep people separated, okay, making sure that people are wearing face coverings, even if they aren't otherwise required to do so. So there's different steps that employers can do if you want to show that you're going to go above and beyond if you're exceeding this occupancy limit. Another requirement is the social distancing of 6 feet, which we all know must be maintained. If the safety of a core activity requires a shorter distance, face coverings are required for anybody who are in closer proximity to one another. Or again, physical barriers may be installed. I know of a lot of companies that are installing plexiglass barriers or curtains between different stations on an assembly line, where employees do invariably need to work closer to one another. Just that's the way the line was set up. That's the way the product needs to be handled as it goes through the line. In some instances, if you can do so safely and you can establish that physical barrier, that's a good idea. Okay. To the extent that there are shared workstations, they should be cleaned and disinfected regularly. Employees can be empowered to do this, right? Show employees how to do it. Just a simple training will go a long way. Okay. Also, use of tightly confined spaces must be prohibited. If a tightly confined space cannot be cut out of the processes or the work environment completely, then additional precautions have to be taken, including wearing of face coverings and a 50% occupancy limit. Okay, an example of this is if there's an elevator. An elevator might have a 10-person occupancy limit in most cases, right? If you need that elevator to keep operating, then you'd want to limit it to one person at a time. If you cannot do that, then anybody in the elevator should have a face covering on, and in that case, it should be limited to a 5-person occupancy. Okay. To the extent you can limit in-person gatherings, and you want to make sure that you have COVID-19 safety signage throughout your plant. Okay, and what does that mean? Well, the sort of things that the CDC and the New York State Department of Health have been emphasizing since before the workplace restrictions were even in place, right? Good hygiene, right? Cough into your elbow, that sort of thing. Cough into your sleeve. Wash hands regularly. If you have symptoms, make sure that you report them. So that sort of signage is out there, it's available, and you want to make sure that it's prominently displayed in your workplace. Next slide. Also under the category of people, right, as far as the guidelines go, there's workplace activities requirements, restrictions, okay? The guidelines state that businesses must implement measures to reduce interpersonal contact and congregation, okay? So that is the requirement. Then there are certain examples of what businesses can do to accomplish that. None of those examples are necessarily mandated, okay? But the state is saying these are the steps that employers should consider to accomplish the requirement of reducing interpersonal contact and congregation, okay? They include limiting in-person staff to only those who are necessary, okay? Adjusting work hours, right? Perhaps, changing your shift structure, that sort of thing. A lot of businesses have kind of gone through, they see that one of the problem points is, the ingress and egress to a building, right? A shift starts, everybody comes in at the same time. That's where you have a lot of people stacked up at a time clock. That's where you're going to have to go through the screening process, and it creates a bottleneck, okay? There may be advantages, and some businesses may be able to stagger the shift start times to reduce the density of employees as they come into the workplace at a given time, okay? So again, these are the sorts of things that all businesses should be considering. Next slide, please. So those are some of the people guidelines, some of the places guidelines, okay, I'm going to talk about now. One of those relates to personal protective equipment or PPE requirements, okay? Businesses are required to obtain and provide acceptable face coverings to employees. What's acceptable is going to depend on the industry, depend on the business, depend on the job task that the individual is involved in. In some instances, a cloth mask may be sufficient, okay, it would be sufficient, or disposable mask. In some other instances, something that meets a higher industry level of safety would be appropriate, okay? In each case, the PPE must be cleaned to replace after use. If an employee prefers to use his or her own face covering, okay, the guidelines say that that employee must be allowed to do so, so long as it complies with industry standards, okay? You don't have to lower your safety bar because an employee wants to wear their favorite bandana, okay? You're allowed to establish safety requirements. If they do have a face covering that satisfies those safety requirements under the guidelines, the employee must be allowed to wear them. Next slide, please. As far as hygiene and cleaning, okay, businesses must adhere to the evolving guidance that's been issued by CDC and the New York State Department of Health. So I would make it a practice to regularly go on their websites or designate somebody to do that, just to make sure that we're staying up to date with the most current cleaning practices, recommendations, and requirements by the government, okay? Employers are required to provide hand washing stations, and if a hand washing station with soap and water can't be installed in a certain area for some reason, then a hand sanitizer station with, I believe the solution is 60% alcohol, is sufficient. So where's a good idea for this? Again, those same kind of pinch points or bottlenecks where employees congregate. Time clocks. I would recommend that there's a sanitizing station near a time clock so employees can clean their hands before they punch in. Just because we want to reduce the opportunity for that time clock to turn into kind of an infection point for your workplace. Also, employers must provide supplies for cleaning and disinfecting shared and frequently touched spaces. Okay, conduct regular cleaning and disinfection of a site with special attention to higher trafficked areas. Ensure regular cleaning and disinfection of restrooms. Ensure that equipment and tools are regularly disinfected. What I would recommend is that an employer, whoever's responsible for this, that they maintain a log, okay? Because if audited, we're going to want to be able to show the exact processes that we're following to ensure a safe work environment. We saw this, we've seen this over the course of the last 3 months, 2.5 months, with investigations that are being conducted at essential businesses, right? Because they receive some sort of complaint that a business is operating or it's not operating in a safe way, okay? And whether it's the Attorney General or the Department of Labor kind of working with the Attorney General, they would come in and do an investigation. And it's really on the employer to establish all the steps that it's taken to provide a safe work environment. And this could just be, another feather in your cap. If you're doing the cleaning anyways, have whoever's doing that cleaning log exactly what their activities are, so we can show that we're making a sincere, reasonable effort to follow all these guidelines, okay? If somebody is suspected or confirmed to have COVID-19, the guidelines require businesses to close off that area, okay? An area that individual may have infected, so that appropriate cleaning and disinfecting can occur, okay? The guidelines speak to closing it off for a 24-hour period, okay? Yet they also acknowledge that in some instances that might not be possible, but in any event, the idea is that we want to be able to control the area, limit the possible area of exposure, and then hit it hard with cleaning and disinfectant. Whether you bring in a specialist to do that, to do a deep cleaning, or whether you have protocols in place, every business is going to handle it differently, okay? But you need to be careful about isolating that area and then taking the appropriate measures to clean it. Next slide, please. All right, now we're on the processes, okay? And this is the third category of requirements. And in some ways, these have received perhaps the most attention. Businesses, the first of these requirements is that businesses must adopt a process to, on a daily basis, screen its employees, okay? There must be a daily health screening. Many companies are going to come up with their own solutions as far as how to do this, okay? And the guidelines don't say there's a specific way to do it, okay? Some companies are adopting, using technology to accomplish this. I've seen apps where they go through and the necessary questions are being asked, and I'll talk about those questions in a moment, but are being asked of employees so they can, go onto the app, answer the questions on their phone, hit submit, and then there's a record of it. I'm not sure that's going to work for all employers, okay, or for all employees working at certain employers, but that's something to look into. Other companies are having employees call in advance, okay, on their way into work as they're sitting in the parking lot before they get out of their car, okay, again, with the hope that they can reduce the bottleneck as much as possible as people are entering the facility, okay, because at some point, as people enter, everybody has to go through the screening process, okay? And it needs to be coordinated in a way to prevent employees from intermingling with one another as they're going through the process. The results of the screening have to be maintained and reviewed on a daily basis. So somebody is doing the screening, and then somebody else at some point is looking at the results, just kind of, frankly, putting a second eye on them to see if there's any concerns, okay? Keep in mind, this is technically health information. It has to be kept confidential. It shouldn't be broadcast to employees or the world, okay? Make sure that you're maintaining it in a confidential manner, okay? The person who's conducting the screening, of course, has to have the appropriate PPE to make sure that they're not exposing themselves, putting themselves in a position to get increased risk of exposure. And they should be trained on all the appropriate CDC, New York State Department of Health, and OSHA protocols for doing the screening. Next slide. The guidelines speak of a questionnaire that is to be completed to assess whether an employee is at risk or has been exposed to COVID-19, okay? It does not speak as to the form of that questionnaire. And again, there's a lot of different ways that I've heard of companies doing this. Some, to me, sound better than others, Some are having employees fill out a sheet and then they're collecting the sheet. Okay. There's advantages to that and there's disadvantages to that. One of the disadvantages that I see with that process is that it can create a bottleneck wherever those sheets are being completed. Okay. Another disadvantage is that, people are physically touching that sheet, multiple people, and then they're being gathered, collected. Okay. One of the advantages of doing that, though, is that there's not the individual who's doing the screening isn't going through the same process with every single employee. They're just collecting the information. Okay. Other people are having a screener ask questions. Okay. And I'll go through those questions in a second. Right. The problem with that is that you can see where a backup could occur as people are waiting to go through that process. So each employer is going to have to think about its own kind of, the physical space and the ways that it can have people go through this process and determine for itself how best to accomplish this requirement without increasing risks. Another option that I've heard of is employers posting signs that employees read, review, and then as they're walking through, they confirm to the screener that they don't have any of the conditions that are required to be reported. If you're going to adopt that sort of model, my recommendation is that you get an affirmative response from the employee. I would not use a sort of opt-out model where an employee's silence shall be deemed as them safe to come in. I would want them to at least, affirm that they've read the sign and have nothing to report. Okay. So what needs to be asked? What we're trying to determine is that no employee who's or anybody who's entering the site has tested positive for COVID-19 in the past 14 days. Okay. Or experienced COVID-19 symptoms in the past 14 days, or knowingly had close or proximate contact in the past 14 days with somebody who is confirmed or suspected of having COVID-19. If an individual answers yes to any of those questions, they should not be allowed on site. Next slide, please. Okay. At the very least, prevent them from coming on site, send them home with instructions to contact their healthcare provider for further assessment or treatment. Okay. And the employer is then required to notify both the local health department and the New York State Department of Health about the suspected COVID-19 case. Okay. The slide here only says local health department. In fact, it's the local health department and the Department of Health. I would suggest contacting the local health department first and then following their lead, because they really are the agency that's going to be responsible for any contact tracing going on. Okay. Next slide. So the guidance does speak to instances where people should be subject to a self-quarantine, depending on how they are screened. Okay, the results of their screen, and that self-quarantine might last for 14 days. And then it also talks about possible exceptions to that. I want to spend a little bit of time going through that. Okay. Under the guidelines, and these kind of echo some guidance that had been really since March put out by the New York State Department of Health, dealing with when people should be prevented from coming into work. Okay. That said, they are constantly evolving, and like anything else, we just need to make sure that we're aware of the current standards. But under the guidelines, what they say is that an employee must undergo a 14-day self-quarantine before he or she is allowed to return to work under certain circumstances. The first is if the employee has COVID-19 symptoms and either tests positive or has not yet been tested. Okay. In that instance, they are subject to a 14-day quarantine. They're presumed, or in the case of a positive test, confirmed as having COVID-19. Okay. The second is if an individual does not have symptoms, they're asymptomatic, but they test positive. Again, they're subject to a 14-day self-quarantine period. And then finally, if an employee has a close contact for a prolonged period of time with somebody who was positive for COVID-19 and is symptomatic, they're going to be deemed positive for purposes of undergoing a 14-day self-quarantine. The guidelines do speak to limited circumstances where an employee who is critical to the safety or health of the site, okay, and they may return in less than 14 days, if it's consistent with the local health department standards and current CDC and New York State Department of Health standards. Like I had talked about before, okay, I would be careful about relying on this exception. I would want to be very deliberate if we're going to say that somebody needs to come into the site in less than 14 days, okay, and make sure that if we are going to try to take advantage of this exception, that we are, going through the process and reporting it to local health department, and we're following. If we're doing so consistent with any guidance that's been issued by the local health department and state and federal guidelines. Okay, so in the past, those guidelines have said something along the lines of somebody has to be symptom free or not had their exposure could not have been within 7 days, and then they must have had 72 hours of not having a fever. Okay. Again, that standard has evolved. We need to make sure that we're following the current standard in place at any time, because this is going to be a very important thing. This could be something that will get tested if somebody tries to sue an employer because of a potential exposure, negligence, okay, somehow exposing employees to risk that they shouldn't have, that are inconsistent with the guidelines. And if the employer is making this decision, it wants to make sure that it's going to be able to defend itself if it's questioned. Next slide. Okay. If an employee had close contact with somebody who's positive and is not symptomatic, an employee can continue working. Under certain instances, the employee has to self-monitor. They have to wear a face mask. They have to engage in social distancing, and all shared workspaces have to be cleaned and disinfected. Okay, this is again for somebody who is not symptomatic. Okay, next slide. And I think this is my last slide. It has to do with tracing and tracking. Okay, all businesses are required to maintain a log, including the names and contact information for any employee or visitor who comes on site. Okay, the idea is that if there is a positive test, you're in a position to notify the local health department or Department of Health, New York State Department of Health, of that exposure incident, and then also cooperate in the effort to trace contacts of that individual. Okay, and the guidelines speak to providing the names and contact information for all individuals who were on site within 48 hours or during the 48 hours prior to the individual or the worker or visitor experiencing symptoms or testing positive. So you're going to want this documentation. So you're going to actually play a role in the contact tracing, okay? And this sort of documentation is required to do that. So at that, I'm going to pass it along to my colleague, Jim Rooney, to talk about some leave issues and some liability issues.
Okay, great. Thank you very much, Mark. So with the remaining time we have, I just want to cover a couple issues. And I'd like to start with the leave laws, as Mark just mentioned. When this pandemic first broke and many of us were sent home and businesses were suspended, there was a lot of attention given to these leave laws. But over time, some of that attention has dissipated. But there's no doubt there's going to be renewed attention as people return to work. And as frankly, people continue to be infected. So it's worth a review of some of the leave laws that will likely apply to your workforce. And there are really two set of leave laws. One is the New York State paid family leave, and actually, more specifically, the sick pay law that was passed in response to the pandemic. And then there's federal law, and federal law is embodied in what's called the Families First Coronavirus Response Act. Next slide, please. So let me talk first about the state law. And there are really two keys to the state law. The first one is it applies only to employees. Some of these other leave laws also apply to circumstances where the employee is taking care of others. But with regard to the state sick leave law, it only applies for employees. The second key is that it only applies if the employee has received an order of quarantine or isolation. And when I say an order, that's a governmental order. And most typically what we've seen in the past couple months, it's been an order that's been issued by the County Department of Health here in New York State. Now, sometimes these orders have morphed into something that a doctor or an employee can actually fill out as well, and there's a form that says that it's supported by the Department of Health. But the bottom line is you want to be looking for some sort of governmental order that says that employee has to stay home. There's some exceptions. There's an exception for if people are engaged in foreign travel. I don't think we're seeing that exception apply very often right now. We're not seeing people even travel to different states, much less other countries. And likewise, if an employee is asymptomatic or has no medical diagnosis and can work remotely, then the law won't apply. Next slide, please. All right, so if an employee qualifies for this, he or she has an order from the government that they have to isolate or quarantine. What do they get? And it really depends on the size of the employer, and in some cases, the annual revenue of the employer. And you can see here, there's a chart that sets forth what sort of paid sick time the employees receive. If you're 10 or fewer employees and the employer has a net revenue of less than $1 million, there is not actually a paid sick time requirement, although the employees are still protected in their leave. But as the size of the employer grows and the revenue increases, employees may be entitled to at least 5 days of paid sick time, or in the case of larger employers with at least 100 employees, they may be entitled to at least 14 days of paid leave for these circumstances. Next slide, please. Just a few details, specifics about the New York State sick leave law. When I say paid leave, what do you mean? And what I mean is they get the regular rate of pay. So during that period of time, the 5-day or the 14-day, which is, by the way, calendar days. So it's 14 days of paid leave. It's how many days that employee would have worked during that 14-day calendar period. And they're entitled to their regular rate of pay during that time. What else are they entitled to? They're entitled to get their job back when the leave ends. And they're entitled not to have, if there's a collective bargaining agreement, there's a union on site, their rights under that agreement cannot be reduced. One thing that's worth noting is an employer cannot force the employee to both use this leave, the New York State sick leave, and paid time off. That is to say, they can't be charging them paid time off during this leave. This leave is something in addition to what employees have already been entitled to. Next slide, please. So now let me talk a little bit about federal law. And there are really two federal laws that apply. The first one is the Federal Emergency Paid Sick Leave Law. And this applies, curiously enough, there was a lot of attention at the time, to smaller to mid-sized companies with less than 500 employees. And there are really two categories of employees who are entitled to leave under this circumstance. The first one are employees who for some reason, have to take care of themselves due to COVID-19. And you'll see here the three that are outlined in this slide is the employee is subject to a governmental quarantine or isolation order, just like we talked about with the New York State law. The employee has been advised by a doctor to self-quarantine, or the employee is experiencing symptoms of COVID-19 and seeking diagnosis. So those three instances where employee has to take care of himself or herself may entitle the employee to federal paid sick leave. Next slide, please. There's another category, and that's when an employee has to take care of others. And you'll see here in the slides, the employee is caring for an individual subject to a governmental quarantine. That's typically someone in his or her household. Or the employee is caring for an eligible son or daughter under the age of 18. And what this really refers to is when a child the school is closed, or their daycare provider is not open, or their other caregiver is not available for COVID-19 reasons. In these circumstances, there would also be federal emergency paid sick leave available to those employees. Next slide. All right, so these are some of the circumstances in which this emergency paid sick leave is available. Now what? What does that mean? What do they get? And what they get essentially for full-time employees, they get up to 80 hours of pay. And this kind of coincides with the state law that we looked at. It's essentially how much pay they would have received during a 2-week period. So for full-time, it's how much they would have, it's up to 80 hours, 2 weeks of pay. For part-time, it's the average number of hours they typically work during a 2-week period. And so the calculation is made on that basis. Next question is, how much do they get? We talked on the state law, they're entitled to full pay. Under this particular law, you do look at their regular rate of pay as it's established under what's called the Fair Labor Standards Act. But there is a cap. And it depends on what category you fall into. So if you fall into that category of employees who are taking care of themselves because they've been quarantined, or they've been advised by a doctor to quarantine, or they are seeking a test because they have shown symptoms. In that case, they are entitled to their full pay, but it is capped at $511 a day. On the other hand, if you fall into the category of employees who are taking care of others in order to get this leave, whether their kid's school is closed, or they're taking care of someone in their household who's COVID-19 positive, then they're entitled to 2/3 of their pay, and that is capped at $200 a day. So that's the sort of paid compensation that employees are entitled to under these circumstances. Next slide. Just a few additional details regarding this law. Employers cannot be required to use paid time off before they're entitled to this leave. And the only paid time off that employees can use under this leave is employers may allow them to use some paid time off, vacation, personal days to top off. That is to say, for those employees who are just getting 2/3 of their pay, they may use with the employer's approval, additional PTO to top off so that they are essentially getting their full pay. The other thing I think is worth noting here, in the interest of time, I'll kind of focus on the most important items, is, as most of you, if not all of you already know, to the extent you're paying paid leave under the federal coronavirus paid leave laws, you get a quarterly tax credit for that amount of money. So ultimately, it should be this entire amount should be subsidized by the federal government. And the guidance that's been issued by the IRS has indicated that includes not only the salary, but also includes the employer's share of Medicare taxes, as well as the extent to which you're keeping people on health insurance, the health insurance premiums during this period of time. So make sure if you're providing this sort of leave that you are taking advantage of it, because it has been set up in such a way that you should get a full tax credit for this amount. Next slide. And then there's one additional leave law under the federal government's expansion of leave laws, and that's an expansion of the Family Medical Leave Act. Now, most employers that have at least 50 employees are familiar with this law, but what's unique about the coronavirus expansion of the FMLA is you don't need 50 employees to be governed by this law. It applies to any employer that has less than 500 employees. Even if you have 10 employees, you're going to be bound by this law. It is, however, a fairly limited law. We just talked about the emergency paid leave law. This only applies to one circumstance, and it's actually one of the circumstances we just talked about with regard to the emergency paid leave law. This applies to employees who need leave in order to take care of a child who is under 18 because their school is closed or the daycare provider is not available. So it's that one unique need that may allow you an extension of your leave under the Family Medical Leave law. Now, for those, whether or not you're familiar with the Family Medical Leave Act, it's worth keeping in mind that the Family Medical Leave provides employees with up to 12 weeks of leave annually. This does not give additional weeks beyond their family medical leave allotment. So if, for example, an employee has already used 12 weeks of family medical leave for other purposes this year, this law will not give them anything. They've already exhausted their 12 weeks. Another way of putting this is they get whatever FMLA time is they have not yet used during the course of the year. And remember, it is 12 weeks. The way this is set up is the emergency leave that we talked about is a 2-week period, as I mentioned. The family medical leave would already begin, the clock would begin running at that time. So once you exhaust the emergency paid leave, assuming the employee has not used any other family medical leave during the year, then this would kick in and they would have an additional 10 weeks of leave. Again, this is a 2/3 cap to $200 a day. Next slide, please. So let me just very, very briefly address some other additional general liability issues. We've seen some lawsuits come out of coronavirus. You know, lawyers being who they are, we are going to see a lot more lawsuits in the coming months, if not years. We've already seen some in nursing homes. We've seen some with colleges. And I think particularly as the courts resume and become more active, we're going to see more lawsuits in the nature of personal injury lawsuits. And there'll be typically, when it comes to employers, it will be third parties, that is non-employees suing them, or employees will try to seek some sort of remedy from their employer. Next slide. So with regard to third parties, that is non-employees, how are these going to be analyzed? Well, you know, to some extent, we have this is uncharted territory here. But the basic principle of negligence claims, the typical personal injury claim, requires that a party be injured and that it be caused by the defendant, and that the defendant had failed to act as a reasonably prudent person would. Well, that's really the rub here. How does a reasonably prudent person act when they've returned people to work and are dealing in the public during an unprecedented pandemic? That's really hard to determine, and juries and courts are very much going to struggle with it. So when we talk about giving advice in this area, we really have to talk about what are courts likely to look at in terms of what the duty of care is. I mean, how are we going to judge how an employer should behave? And it's really governed by what Mark talked about. What we have now is we have guidance from the governor, we have guidance from the federal government, we have it from OSHA and the CDC telling businesses how they should behave and setting forth specific requirements as to what they should do. Clearly, if there are lawsuits that are brought, that is the first thing that the courts and juries will be looking at, is to the extent to which you have followed the guidance. And similarly, to what extent have you followed your own safety plan? As Mark said, there has to be a safety plan that you create, has to be posted. To what extent have you followed it? Those will be critical. Next slide. And by talking about this issue, I don't want to suggest that these are going to be easy lawsuits to bring. I think that's absolutely not the case. There are some enormous obstacles that face plaintiffs bringing these sort of cases. And most prominent among them is causation. How are they going to be able to prove that they were infected and ultimately suffered some injury because of the defendant's actions? Particularly when we know that the virus is sometimes carried by people who are asymptomatic, and people are out and about, and it's hard to know where someone got it. So causation is going to be very difficult. And there's something also called contributory negligence. To the extent someone sues and they themselves haven't been wearing a mask or haven't been engaging in social distancing, that's going to make it extraordinarily difficult to bring a successful lawsuit. No doubt discovery in these lawsuits will largely focus on what those individuals did. Next slide. So then finally, let's just talk very, very briefly about liability to employees. Can your employees sue you because they were infected and injured by the coronavirus? And for the most part, the answer is no. As all of you know, you carry workers' comp insurance. I'm sure you're familiar with, to some extent, with the workers' comp process. And while the workers' comp process can be annoying, there is one great benefit to employers, and that is it generally bars prevents employees from suing you for injuries that take place in the workforce. And we believe that that workers' compensation bar will in fact preclude most lawsuits brought by employees. There is one general exception to this. It's sometimes referred to as a grave injury exception. And the way this applies is if an employee sues a third party, let's say, for example, the employee sues the owner of the property where they work. It's different than the employer. And that third party feels that the employer bears some responsibility. That third party can then, what's called implead, essentially sue the employer to bring the employer into the lawsuit. So there's a lesson here. To the extent you're dealing with third parties, including an owner of property, if you don't own the property where you work yourself, you want to make sure that they're operating in good faith and complying with the various requirements that Mark outlined. Because if they're not, and your employees get sick, and somehow they can prove that they got sick as a result of that, that third party can be brought into a lawsuit and in turn try to bring you into a lawsuit as well. So you have to be careful not only about what you're doing, but what those around you are doing, including your contractors and otherwise. Last slide, I think. So I know we're pushing the time limit here. The lesson when I talk about general liability is you take reasonable precautions. You do what your safety plan says. You follow the guidance. You're generally aware of your subcontractors and outside parties. Make sure that if they're exposed to your employees or your customers, that they're acting in an appropriate manner. And then finally, I would mention, anytime you have an issue where you think you have a potential claim, make sure you give prompt notice to your insurer. The reality is here, insurance companies are going to be looking for ways to avoid these claims. There's no doubt about it. And don't give them a good reason for doing it by having failed to give them prompt notice of a potential claim. So that's it. Seth, I don't know if we want to move on, if we have any time left for questions or not.
We do. Mark and Jim, thank you so much for this detailed presentation, and it's generated some good questions. First, and we're talking about state guidelines and what businesses are expected to do. How do you see the ability for levels of government to audit that information? The business safety plan is not submitted to the state, but the expectation that the guidelines will be followed. Who has the ability to come into a business and review the safety protocols?
Yeah, I'll take this one. I don't see there being any sort of restrictions on a governmental health agency, for example, to conduct a random audit, so to speak. I don't think that there's anything that prevents them from coming in. They have general authority to regulate the workplace and to conduct the sort of investigations that would be, in this instance, we'd be talking about as an audit. That being said, what I suspect will prompt most of these investigations or audits would be employee complaints. We've seen that to this point so far. So I think it's going to be mostly employee complaint driven, and frankly, I think we're going to probably see it mostly from employees who have some issue about returning to work and whether they feel as though they should be required to return to work or should be working under certain conditions.
I would also say, I think I agree with everything Mark said, but if there's a rash of infections at a particular workforce, I think you can expect that some governmental agency is going to pay you a visit and take a look at your plan. And likewise, I talked about lawsuits. If a lawsuit is filed, that's going to be the first thing the other side is going to ask for. Let me see your safety plan, and they're going to try to poke holes in it, and they're going to try to show that you didn't follow it. So honestly, I've said this to a client of mine just a couple of days ago. Write it as though others are going to see it, because I think the possibility of that happening is a real one, even if it's not formally required to be submitted right now.
Thank you. Nick puts forth an interesting scenario about employer liability if a person, especially on a manufacturing floor, suffers an injury or health emergency due to wearing a mask in a high temperature work environment. What's your thoughts about employer liability in that type of situation?
I think that's probably going to be barred, but I talked about workers' comp. That's a claim that ultimately would be barred by workers' comp. Now, there's a remedy there. There's a viable workers' comp claim. But I don't see the ways of getting around the workers' comp barrier in being able to file a direct lawsuit against your employer in New York are very, very limited. And I think if ultimately you're requiring someone to wear a mask, and you're doing what the CDC and the state government want you to do, I think it's extraordinarily unlikely that the employee in that circumstance will be able to circumvent the workers' comp process.
Okay. And this is going to be the final question about testing logs or entrance logs. That, in your opinion, should employers be logging delivery trucks as well if they're not using proper PPE? Should they be logging all subcontractors coming in the same way that they're logging their employees?
The guidelines actually speak to logging deliveries. And what they say is that deliveries that are performed with appropriate PPE and through contactless means do not need to be logged. Okay. So if you have a delivery driver who is wearing all the PPE and there's no immediate risk of contact that would contribute to an infection, that individual does not need to be logged. You just need to make sure that those thresholds are being met. As far as subcontractors in general, yes. I mean, if they are spending time on your site, if they are working on your site, they should be logged as though they were really an employee.
Thank you. And I want to thank again Mark Moldenhauer and Jim Rooney of Schoeneck and King for the time and the information here. There was a question about whether this presentation will be sent out. The answer is yes. We will actually make the entire recording available on our website. So, gentlemen, thank you again.
Thank you.
Thank you. I want to also remind everyone that we will be meeting again Thursday, June 4th at 8 a.m. to talk about lending, tax changes, and the future of PPP with the Bond Deal Group. Thank you again to Bond for your time here and your expertise. And as always, thank you to our Manufacturing Council sponsors, title sponsor Bank on Buffalo, industry sponsors Harris Beach PLLC and National Grid, and supporting sponsor Remedy Intelligent Staffing. Everyone, thank you for your time and have a great day. Take care.
Thank you.